The Board of Directors. Some roles and responsibilities of the Board of Directors of a corporation. The Board of Directors acts in the interests of the shareholders. The Board acts as an agent of the shareholders and owes fiduciary duties to them. When the Board of Directors has interests that are not aligned with the shareholders, such as in merger and acquisition transactions, when the directors and managers are likely to lose their jobs, or such as when the director is selling an asset to the company or is otherwise self-dealing, the fiduciary duties are heightened and the director's decisions come under heightened scrutiny. Although the board is required to act in the interests of the shareholders when the company is solvent, the focus shifts to the creditors and the other stakeholders when the company finds itself in the vicinity of insolvency. The board cannot act solely for the shareholders if this will harm the creditors when the company finds itself insolvent or in the vicinity of insolvency. The shareholders cannot organize the corporation in such a way that the board of directors is passive or mechanical to the will of the shareholders. Corporations are creatures of the state, and state law prohibits sterile puppet directors. Shareholders have powers to remove a director from the board, but they do not have powers to alter the state's corporate statutes. The director's duties are not to certain shareholders. The duties extend to all the shareholders and the corporation itself. So venture capital investors acting as directors are required to act as agents for the company, not merely agents for the investment fund. The duties of members of the Board of Directors are well defined and extensive. The board is required to manage the business of the corporation and can be held responsible for the actions of the company. According to the American Law Institute, the Board of Directors has powers to hire, fire officers, including the CEO, oversee management, review and approve audits, and make recommendations to shareholders. An inside director is a company insider, such as an officer, founder, employee, investor, or someone otherwise affiliated with the company. Outside directors are not recruited from inside the company, so they bring an independent, outside perspective that is considered valuable for management and corporate governance. Outside directors are often tasked with setting the compensation of the CEO and other officers. Members of a board of directors can face lawsuits from shareholders or employees that are unhappy with some aspect of the way the company is being managed. Board members can be forced personally to pay damages when they're found to have breached their fiduciary duties. 10b-5 fraud cases are a common reason for lawsuits and damages. Although we generally avoid stating specific rules in these lectures, we make an exception here for 10b-5, as this is one of the most noteworthy rules promulgated by the Securities and Exchange Commission in the United States, and it acts as a catch-all for various types of business fraud. Directors can sometimes face criminal liabilities including jail terms and fines. Following corporate scandals in the United States, the Sarbanes-Oxley Act was passed and raised the jail terms and potential liabilities for directors of publicly traded companies. Members of the Board of Directors can worry about potential liabilities, but they are provided with some protection when making decisions on behalf of the company. Under the business judgment rule, the court will not second-guess decisions made by directors and officers if the decision was made with good faith, under a duty of loyalty to the company, and under a duty of care to the company. For example, the directors of Wrigley Field Baseball Stadium were found not to be liable to pay shareholders for the loss of profits as a result of the board's decision not to install floodlights and hold games in the evenings. The shareholders may have been upset that the decision resulted in lost revenues and profits, but the decision was protected and shielded by the business judgment rule, and the directors were not held liable. There are situations where the shield of the business judgment rule disappears, and directors can be held liable for board decisions that harm the shareholders. The shield of the business judgment rule disappears when the interests of management and the shareholders diverge, when the loyalties of the directors lie somewhere other than with the shareholders. For example, the business judgment rule will not protect a director that's self-dealing when the director has a personal gain from the transaction under question. When the business judgment rule disappears, the director has to show complete fairness in both the price agreed and the decision process leading to a transaction entered into by the company. These situations often arise when the company is for sale and the directors are protecting their jobs rather than protecting the interests of the shareholders. The directors have to auction the company essentially to the highest bidder if they are to show complete fairness and avoid lawsuits from disgruntled shareholders later on. Bearing in mind their exposure to potential liabilities, company directors often look for indemnification and directors' and officers' insurance when making the decision to sit on a board. The company can indemnify the director and step into his or her shoes to answer a lawsuit and claims levelled at the director. In this scenario, if the director is held liable and forced to pay damages, the damages and the legal fees will be borne by the company. It's common for companies to have indemnification of directors written into the bylaws, so indemnification is often provided by the company. In addition, the company can buy directors and officers insurance to cover the legal costs resulting from a lawsuit. Insurers do have certain requirements before taking on a company, one of which is the company needs an employee handbook defining the corporate policies and procedures for employees to follow. Directors and officers insurance is hence often available to and is purchased by larger, more established corporations, but is not available to and is not purchased by smaller startups. Does an individual director have any significant power or authority? The answer is no. An individual director cannot sign a contract that binds the company, unless the director is also an officer and is acting in his or her capacity as an officer. The board of directors acts as a single unit, a single board, and has collective responsibility to manage the company. A board member has to be a person. An LLC or corporation cannot act as a director and sit on a board. Companies may be considered people in the eyes of the law, but not when it comes to sitting on a board of directors. The director has to be a living, breathing human being.